Good afternoon, everybody. I hope that you can hear me okay. I'm going to look at Steve to nod if it's all right. Before we get started, I'm just going to share my screen so that you can see our slides. Give me 1 second. And I'm looking again at Steve to see if that's working all right. Brilliant. Okay. Thank you so much to everybody who has joined in. There's a huge number of people with us today. And I think that that really reflects the level of worry and questions about this issue. We wanted to put on this webinar for you all today, really in response to so many questions that we've all been having over the last couple of weeks. And so what we hope is that we will just be able to provide you with an overview of what the current state of the law and guidance is today. Of course, though, all we're able to do is say what the law sets out today. And the guidance is changing quite frequently at the moment. And I think indeed we're going to have some more before the start of September. So if I can first of all just introduce our two other speakers today. We have Alice Irving, who is a barrister at 1 Crown Office Row, and she's going to be joining Doughty Street Chambers in September. And also, if he does need introduction, then we have Steve Broach, who is a barrister at 39 Essex Chambers. And the three of us have been working quite closely recently on the judicial review challenge against the downgrading of the legal duties for children with special educational needs and disability during the coronavirus pandemic. So before we start, I just wanted to mention briefly that this is a free seminar, but we are asking where people feel able to make a small donation to Able Child Africa. And I'll just hand over to Steve briefly just to say a few words about the charity.
Thanks very much, Polly. Good morning. Good afternoon, everyone. It's been a long day already. And very pleased to be here virtually with you all. And very pleased that Polly was kind enough to suggest that anyone who's in a position to do so could support Able Child Africa in the light of this event. I was at one point lucky enough to be chair of this incredible organisation, and still a very staunch supporter of a charity that I think is still unique in being a Pan-African support organisation for disabled people's groups, parent groups and others working in different countries in Africa, promoting the rights and interests of disabled children, children with disabilities, to use the UN's language, across the whole spectrum of life, but focusing in particular, of course, on education like we are today. And Able Child Africa very much takes a rights-based approach, trying to ensure that disabled children in Africa can access the same kinds of entitlements that disabled children in the UK should enjoy, but we know too often don't. And so if there is any way people can show solidarity across the seas and support the work that Able Child is doing in Africa, that would be fantastic, but fully understanding that not everyone who's attending today will be in a position to do so. So thanks again to Polly for choosing Able Child Africa to benefit from today's webinar. I know that the staff there are very grateful for people's support already.
Thank you, Steve. So what we plan to do is to have about an hour where I'm going to ask Steve and Alice some questions. And the questions which we've had so many questions in over the last couple of weeks as well from parents, and they all broadly have the same kind of themes and worries. So I'm going to ask Alice and Steve some particular questions which I hope are going to be really helpful for everybody. And then we're going to try and have time at the end for about 15 minutes of Q&A. Please do ask questions. Of course, we aren't able to advise on individual facts of individual cases, but we are able to talk to you about what the law says. So please just bear that in mind when popping questions in the Q&A. Also, this is going to be recorded and a copy of the slides will be circulated after the event. So what we have set out first of all is some key resources. And these are all resources which are specifically related to changes arising because of coronavirus. And you'll see in the slides when they're circulated after that we've put links in because the guidance is updated quite regularly, and if you use the link, then it will take you to the latest version of the guidance, which is on the DFE website. So we'll talk about these bits of guidance in a little bit more detail, but you have them all here, and then some more detailed checklists and guidance from other sources there. I think the other thing to say by way of headlines is that it's really important, and I think Steve and Alice are both going to touch on this, to think about what the law said, what legal rights were before coronavirus pandemic, because all of these resources are basically changing the existing law. And what's happening in September is that we're restoring back to what the law originally said. So all of these were only temporary changes in many areas. So I think Steve's going to also remind us of what used to be in place as well. So first of all, Alice, if I can start with you and ask you what the latest guidance says about reopening of schools from September.
Great, thank you, Polly. So the second hyperlink there on the first slide is the relevant guidance here. So that's the guidance for the full opening of schools. And as Polly's noted, that's going to be kept under review and maybe updated. So this is guidance which isn't binding on school leaders. It doesn't create any new legal obligations, but it gives you an idea of what they ought to be doing. And it covers a lot of stuff, but it also covers specifically what should be provided for children with SEND in mainstream schools when schools reopen in September. So the headline here is that the plan is for all pupils to return to school full time from the beginning of the autumn term. And in particular, schools should not be putting in place rotas. Now, I understand that a lot of schools have been putting in place rotas to keep student numbers down. That should cease at the beginning of September. Now, schools also should be carrying out a full risk assessment to prepare and to take what is described as sensible and proportionate measures to reduce risk. Now, what's really important here, and that's obviously some quite woolly language, is that whatever measures the school adopt to manage the risk of the virus should allow them to deliver a broad curriculum, and that includes, and it explicitly states this in the guidance, it includes them providing full educational and care support for pupils who have SEND. So schools should be ensuring that appropriate support is made available for pupils with SEND, and that includes deploying teaching assistants and enabling specialist staff to come in and access the school to work with pupils. Now, I understand as well that teaching assistants have often been redeployed during the pandemic, which has sometimes meant that provision for students with SEND has been diverted and they've been missing out. The guidance specifically clarifies this and says that teaching assistants can be used to cover sort of gaps in provision, but that should not ever be at the expense of supporting pupils with SEND. So the guidance is saying all the right things that we might want to hear. In addition, the guidance recognises that some pupils with SEND are going to have difficulty coming back to school because of changes of routine and the big break that they've had. And so that teachers and special educational needs coordinators should plan to meet those needs, for example, using social stories for example, with pupils with ASD. In terms of what will be done to manage risk in schools and how that might impact particularly on pupils with SEND. Schools are required to do what they can to minimise contact between individuals and to maintain social distancing where possible. But the guidance notes that for some students, being younger students and some students with SEND, it's not going to be possible necessarily to maintain social distancing. And the approach suggested in the guidance then is for the use of bubbles within the school so that there's less reliance on the need for pupils to be able to self-moderate in terms of social distance. The guidance further goes on to recognise that obviously social distance isn't going to be possible to maintain in relation to some pupils who have contact care, close contact care, and who have complex needs. And the guidance is clear that their educational care and support should be provided as normal and that specialists, therapists and clinicians and other support staff for pupils with SEND should provide interventions as usual. Now, PPE might be needed in some of those circumstances, and there is specific guidance on that available on one of the slides. And I understand that Steve later will be addressing specifically the question of students who require aerosol generating procedures and some of the ways in which schools can handle that. So the takeaway from all of that is that schools are expected effectively to have all provision in place in September for students with special educational needs and disabilities, and they shouldn't be diverting any of those resources elsewhere.
Thank you, Alice. What we do know, though, is that over the last couple of months, the government has introduced measures which have removed the legal rights of, or downgraded the legal rights of, many children and young people with special educational needs. When schools reopen in September, what rights will children and young people with special educational needs have to the provision that they're entitled to usually?
Certainly. So during the pandemic, there have been two major changes to the rights of individuals, particularly with education, health and care plans. The first of those is fairly significant. Under the Coronavirus Act, it gave the Secretary of State for Education the power to issue a notice. And the effect of that notice would be that for 1 month, the duty on local authorities and health bodies to provide what's set out in a child's or young person's educational health and care plan, that duty, instead of being you have to provide this, became you have to use reasonable endeavours to provide this. And what we know, unfortunately, is that there's been a wide range of responses from local authorities in interpreting what that means, and that many children and young people have been left with very little provision. So that was the first big change that happened in response to the pandemic. There have been notices issued that had that effect in May, June and July. In the guidance on temporary legislative changes relating to coronavirus, which is the top link there on the screen, which was updated on 6th of July, the Minister has confirmed that there won't be any further notices issued that downgrade that duty unless the evidence changes. Now, this is a bit woolly. Effectively, it means that in August, it's safe to say that that duty to provide what's set out in a child or young person's education, health and care plan will be back in full force like it was before the pandemic. But we don't have a firm promise from the government that they won't downgrade that duty again. It's going to depend on the evidence going forwards. So it's going to be really important to watch this space. By the time things are coming back and people are going back to school in September, the hope would be that there aren't any further notices issued, and that means that pupils will be entitled to their full provision under their education, health and care plans from their local authorities and from the relevant health bodies. And if they fail to provide that, that they can be held to account. But as I say, things may change. Now, the second change that was made in response to the pandemic related to timescales for local authorities carrying out education, health and care plan assessments, as well as issuing how long they could take to issue an education, health and care plan, how long they could take to issue an amendment following an annual review, and how long indeed they could take to comply with an order of the first year tribunal if a parent successfully appealed an EHC plan to the tribunal. Now, before the pandemic, there were fairly strict timeframes set out in regulations, which said, local authority, you have to take the step within X number of weeks for each of these different steps. What happened in response to the pandemic were some regulations were introduced amending that, which effectively means there's now what they call a coronavirus exception. This means where it's not reasonably practicable for a local authority to meet a time frame because of the pandemic, they need only do so as soon as reasonably practicable. And so you've got this kind of vague language again of reasonableness, which obviously gives a lot of discretion to a local authority. We're obviously concerned about this because we know, again, that prior to the pandemic, there were already difficulties in having local authorities comply with timeframes in some areas. So what effectively this change has meant is that local authorities aren't subject to strict time limits anymore in the EHC plan process, which means they might be taking longer to assess someone for an EHC plan if an assessment has been requested, or they might be taking longer to issue or finalise one. And it's harder for us to challenge that because the standard is more woolly. It's not a strict test. Now, these regulations are meant to stay in force until the 25th of September. So they will still be in force at the beginning of September. And we know that the government is currently considering whether they need to be extended or not. Now, it's these two changes, so the changes to the duty to provide provision set out in the EHC plan, and the changes to the amendment regulations in terms of timeframes for compliance, that the subject of the legal challenge that Polly mentioned earlier in this webinar. So we are next week representing two very brave families who've brought a challenge. We'll be arguing that these changes to the duties owed to children with education, health and care plans ought not have been made, or something loosely like that. So we'll be providing updates about that legal action on our Twitter feeds, and that's something else that might lead to changes in the area. And I see a question in the box, I may as well do it just while I'm here, from about what specific timeframes the coronavirus exemptions apply to. And that is just dealing with education, health and care plans, and the timeframes set out in the special educational needs and disability regulations governing the EHCP process.
Thanks so much, Alice. So I suppose the takeaway points then are education, health and care plans back to the normal position pre-coronavirus from September, but in terms of the timescales to do things, there is likely to be some further delays and not entirely complying with the usual rules until the 25th of September. But that we are expecting the government to make an announcement during August, I guess, to tell us whether they're going to be extending that period beyond September or bringing it to an end in September. And I guess the only other point is perhaps to mention that the government has indicated that it's going to consider local flexibilities in terms of the notices. And so what that means is not entirely clear because it's only mentioned very briefly in the guidance. But I think that perhaps what is envisaged is something like we saw with the Care Act easements, so that each individual local authority, for their own particular needs of their area, might decide not to comply. But it's important to make clear that no decision has been made on that at the moment. And so it's consistent across all local authority areas for now that they'll need to comply with their usual duties in providing what's in an EHC plan. Thank you, Alice. Steve.
Hello, Polly.
Hello. So the sorts of concerns that parents have been coming to me with, broadly, I think you can split into two areas. There are a group of parents who are really worried about their children returning in September and that it's not safe and are asking me, what will happen? And then there's another group of parents who really want their child to go back to school in September, but perhaps that's being met with resistance, or they're being told that's not possible. So taking the first one then, I suppose my question is, do parents have to send their child or young person back to school in September? And what are the options?
The government's position on that question, Polly, seems to be yes, in essence. If the child is on the school roll, then they should be attending in September. So the shielding concept no longer applies from September, and every child is expected to resume full-time education. Of course, major caveat there, we know lots of children with SEND don't get a full-time education in non-pandemic times, but in principle they should, and they should be attending full-time from September. So that's the strict legal position. My anticipation is that in a number of areas, there will be sensible discussions between schools, medical professionals and parents about the way to actually manage in real life a transition back to school for children with complex special educational needs, children with severe disabilities. For example, to take a non-medical point, the process of restoring full-time education for children with autism might need to be very carefully managed. It might be completely inappropriate to expect a child who's been out of school for some time to suddenly start going 5 days a week. And those are going to be sensible adjustments that local areas can make, and hopefully will make. But the strict answer is that there is going to be a duty on parents to continue to secure suitable education for the child, the Section 7 duty in the Education Act. And it will only be if there's a recognised exemption from that they will be allowed to not do it. What I think immediately flows from that then is issues around home education and this concept of elective home education. What I was going to do, Polly, if you want to give me control of the screen,
yeah,
I'm going to try and share, yes, so thank you. Share my screen for a moment. Just going to close my email down first and show people the relevant guidance on that. So hopefully you've got my screen now. And here we have the elective home education guidance that was last updated in 2019. And the key word here, of course, is elective, because we know that lots of children with SEND are educated at home because their families consider that there's no suitable provision for them anywhere. Elective home education is supposed to be a choice. So we're imagining a scenario where the medical professionals say this child can go back to school, but the parents are still unhappy about it and so want the child to be educated at home. That would be genuine elective home education. Can a parent do that? Well, the short answer is yes, they can. But in order to achieve that, they have to take the child off the school roll. And so this is what the guidance tells us in the introduction, that parents have a right to educate their children at home, and the government wants the many parents who do it well to be supported. Most parents who take up the weighty responsibility of home education do a great job, and many children benefit from being educated at home. So you can almost hear the but coming, can't you? And the but is coming in the next paragraph, because the past 2 years have seen a very significant increase in the number of children being educated at home. Pausing there, I'm not entirely sure if the reasoning for that has been properly interrogated. And there's considerable evidence that many of these children are not receiving a suitable education. Less well evidence, but increasing concern that they may not be safe. And this is a very interesting sentence, I think, to find in departmental guidance. I'll just highlight the words that I'm coming to. So although the primary responsibility for ensuring that children are properly educated belongs to parents, so that's a reference to the Section 7 duty, a local authority has a moral and social obligation to ensure the child is safe and being suitably educated. I'm not sure quite how many local authorities would be able to identify that moral and social obligation or what the source of it is. But local authorities, of course, have a legal obligation, important legal obligations in relation to safeguarding. And Section 175 of the Education Act 2002 places those obligations firmly on their education functions as well. So I might say that actually you could say the local authority's got a legal obligation to do those things as well. But in any event, whatever the source of this obligation, it suggested local authorities need to act to remedy the position if they're concerned. And this guidance is supposed to tell them how to do that. And you see this section in bold here, where necessary, because it's evident that the child is simply not receiving suitable education at home, and the use of school attendance powers is not achieving a change in that situation, the local authority should be ready to use its safeguarding powers, as explained in the guidance, with the overriding objective of protecting children from significant harm. And so we then get this slightly terrifying, frankly, flowchart that appears at the beginning of the guidance. And so we see the first thing the local authority is supposed to do is make informal inquiries and ascertain whether the child is in fact receiving suitable education at home. And if they find that if they appear not to be, if the local authority's view is they may not be, then the first thing the local authority is supposed to do is serve a notice on the parents, requiring them to provide information. And if after having received that information, or not, of course, the local authority is still not happy, their next step is to serve a school attendance order. And it's only where the school attendance order is served that then becomes a legal obligation to send the child to school. That becomes the place where the suitable education must be provided. And then if the child still doesn't go to school at that point, there are two routes available to the local authority. One is to prosecute the parents, or the other is to seek an education supervision order. So the prosecution would then, of course, lead potentially to a fine, or a conviction of a fine. If they go straight to the education supervision order, what you're then heading towards is potentially a care order and the child being taken into care. Now, I should emphasize, before I terrify absolutely everyone on this webinar, that these are supposed to be the end products of a much longer conversation. And most of the cases should, of course, be sorted out at this end of the spectrum. But these powers do exist. And I think it's very striking that right at the beginning of the guidance, we now have this flowchart setting out where this all leads to in the event the local authority are still not satisfied with what's going on. So yes, parents have rights not to send their children to school if they wish to home educate, but they also have responsibilities, in particular to ensure that the child is getting a suitable education at home. And if those responsibilities aren't complied with, then there are a number of steps available to local authorities, as we see. So I hope that's a sobering but useful answer to the question.
I think it's important that that parents and carers understand what their options are in these circumstances. So that I think summarises the position for those who are concerned about children and young people going back in September. What about the opposite? So already parents, I think, are being told by schools that they won't be able to accommodate their children for various reasons on a full-time basis from September. So that might be you have to come back on part-time, or you could come back, but we're not going to be able to provide you with a teaching assistant.
Yes.
What's the position for those families?
Well, I think that's much more likely to be the scenario, frankly, in many cases, in practical terms. And in that situation, the entitlements will vary greatly depending on whether or not the child or young person has an education, health and care plan. Because if they do have an EHC plan, then the expectation is that their entitlements will be the same as they were in February, i.e. there will be an absolute duty on the local authority to secure the education provision that's set out in Section F of that plan, and an absolute duty on the clinical commissioning group to secure any health provision in the plan, pausing their social care provision being governed by other legislation. In essence, for social care, all the plan does is pull together what's required under other children's social care legislation. But in terms of core education entitlements, they'll be fully restored, we anticipate, in September. And so if therapy provision or one-to-one teaching support or any other kind of provision is properly quantified and specified in Section F of the plan, then it has to happen in exactly the same way as it did before. The leading case on this is a case against North Tyneside Council. And in that case, Lord Justice Sedley referred to what he described as a margin of intractable cases where the court might not make an order requiring the local authority to secure the provision. But that was very clearly expressed as being an exceptional situation. Now, the exception may become slightly more common during the pandemic, but it's still not going to be any kind of routine excuse because the government has taken a decision. Secretary of State has taken a decision, we're told, not to issue another net downgrading notice for September unless the evidence changes. So the system now assumes that all provision that's in EHC plans can be made from September. And if a local authority wants to argue otherwise, they're essentially going to have to try and persuade a court, if a claim is brought for judicial review, that the judge shouldn't exercise his discretion to grant relief because of some very particular factor. So in the vast majority of cases, I'd suggest, if it's in an EHC plan, there's a legal requirement for it to happen. If this child doesn't have an EHC plan, then they're in a much more vulnerable position, of course. And there, I think, perhaps the most relevant legislative entitlement is going to be under the Equality Act, which has not been modified at any point, of course, during the pandemic. So obligations on schools to make reasonable adjustments are and will be in place. And the reasonable adjustments duty now does cover the provision of auxiliary aids and services, which can include people. So any additional support the child might need will have to be provided as a reasonable adjustment to general policies, general provision criteria and practices, PCPs, if it's reasonable for the school to do it. And that, of course, does allow the school to take account of its resources. But it can't just give a blanket answer, oh no, we can't afford it. There'd have to be a proper analysis of whether the cost outweighs the benefit and so on. But it's much harder, obviously, to enforce rights to provision if you don't have it neatly set out in an EHC plan than if you do. And that's in large part why we have EHC plans, to provide that legal guarantee of provision for children and young people with the most complex needs, to use an unhelpful phrase.
Thanks, Steve. Steve, what about the position of children who until or currently are shielding, or children who have very complex medical needs?
Yes.
Will they have to go back in September as well?
The answer again is yes, at least in theory. As a matter of law, yes. Could you go to the next slide, Polly, and click on the guidance that deals with this for me?
Yeah.
It's the safe working guidance, isn't it? So we see the second link on the slide. Hopefully this is going to work and we'll be taken straight to the relevant section of this guidance. I'm pausing here to note how much guidance there is that schools and local authorities and parents have been deluged, really, haven't they, by guidance in this area. Are you going off to your browser? Here we go.
I am.
Look at that. Here's what we made earlier. And then if you could search the very helpful phrase "tracky" for me, or if you know which link to click, it'll take us to the relevant section, won't it?
Yeah. Oh, no.
Oh, no, it takes you into Vietnam being a country of concern. Let's try again.
There we go.
So you can see there's a specific section of this guidance on children with complex medical needs, and tracheostomies are given as the key example. And of course, in a coronavirus context, the real concern arises in relation to what are described as AGPs. So that's a medical procedure which increases the risk of transmission through aerosols being transferred from the patient to the caregiver. And that will be in particular used for children who receive tracheostomy care. And what's said essentially is schools need to make it happen. So there are specific obligations or at the very least guidelines in terms of the relevant PPE that will be needed, and you see that in the bullet points. The respirator must be fitted by someone trained to do so, fit testing and so on. The procedure should be carried out in a designated room, etc. But what isn't going to be acceptable is just to say, oh, this child can't come to school because their needs are too complex, because that would be blatantly discriminatory, particularly in a context where the Secretary of State's guidance tells people how to do it. So schools must make those adjustments, I'd suggest, in order to avoid children with most complex health needs being disadvantaged and being kept out of school. And that doesn't really say anything particularly different to the general guidance on schools meeting children's medical needs under Section 100 of the Children and Families Act. At all times, the schools have the primary obligation to meet medical needs and to ensure that children are able to be in school. And what that guidance says, the main guidance, if you like, is that where needs are particularly complex and potentially particularly expensive to meet, that's when clinical commissioning groups should be expected to get involved and support the process. And that's very much a separate obligation to the obligation in relation to EHC plans, because of course a child can have very complex health needs and not get an EHC plan, because the EHC plan gateway is exclusively relating to educational needs. Often they will go together, of course, but it's not always the case. So these obligations in terms of not disadvantaging children with complex health needs and keeping them out of school are effectively twin obligations under the Equality Act and under the Section 100 duty. They've got nothing to do with the EHC plan. And children without plans should be treated in the same way as children with plans in this respect.
Thanks, Steve. And so I think that particular bit of the guidance, I think, is useful if you're a family or a professional who is involved in a case where these particular issues apply. Do look at the detail of what that says. The other point, I suppose, with children and young people who have got complex medical needs, of course, the shielding list is going to come to a very abrupt end in August. But the guidance does also say that where families agree with the relevant clinician that it isn't, that it is not safe for the child to go back to school in September, that the government recognises there is still going to be a very, very small number of children in that cohort.
Yes.
And if it's agreed with the medical professional, then the child and the family, the child doesn't have to go back in September. But that isn't an exception. That's the usual law, I suppose, is that children don't have to attend school generally if there is a good reason, including because of their health.
Yes.
So there is that, but I think there does need to be an agreement with a medical professional. That's not a decision which the law allows the parent to make on their own.
Well, yes, or at least it may not be. I mean, I think that's the key point, isn't it? And certainly, probably that's extremely good advice that any parent would do well to have objective support from a medical practitioner. But essentially, this is probably putting it too broadly, but the way I see it is that if you're not sending your child to school, you need an objectively good reason not to do so. And if you have an objectively good reason not to do so, then you're probably going to have a defence in relation to the various nasty things that might happen to you, whether that's be through the criminal procedures or through safeguarding routes. But people may disagree about what is an objectively good reason. And so you do need to be careful. And at the point where the system starts to take issue with your decision not to send your child to school, you will need advice very carefully on particular facts of your case, and you will want independent support for your position. And I think there will be some very hard cases where there are disputes between parents, medical professionals, schools and local authorities about what the appropriate course of action is, and where the system may come down hard on parents in that area. However, I think those are going to be a very difficult but very small minority of cases. And I'd expect the much greater majority of cases will be the other way around, with parents and young people saying, we want to be back at school, and the system not being able to accommodate that in practice despite clear legal entitlements. And the remedy there will generally be judicial review. Although, just to pick up one question that's been asked, where it's pointed out that it's the local authority isn't the barrier, it's the school. Disability discrimination claims can, of course, be brought against schools, and those claims go to the tribunal, the same tribunal that deals with EHC plans. And legal aid is available in a very modest sense, at least, for those claims if the parents are eligible. So, or the young person for over 16 probably knows this much more than I do, but that's my understanding. So it's not the case that only local authorities can be challenged. Schools can be challenged through disability discrimination claims, but they can also be judicially reviewed as well. There are judicial reviews brought against schools. So legal remedies exist in relation to schools not acting reasonably and not complying with the law, just as much as in relation to local authorities.
Thank you, Steve. And just so we're clear in relation to fines then, the guidance really emphasises that schools should be taking this consistent approach to school attendance from day one. Yes. And I think it even says that if a child doesn't attend from the first day, the schools should be telephoning and finding out why and applying their usual attendance rules. And so if a parent is faced with a fine, just remind us what they do in those circumstances. At
the point where you're getting threatened with criminal sanctions, you need criminal law advice, of course. It's very, very important. And any education solicitor will know that there's a line across which it stops being there. Stops being appropriate for them to advise. And unfortunately, a colleague who specialises in criminal law will be needed. And it's the same at the bar as well. There's a point in the system where it flips, and essentially that's after a school attendance order has been served, and then there's no compliance or alleged non-compliance, and then the threat of prosecution arises. My overriding point would be, don't let it get that far. And the way to not let it get that far is to recognise that there's a dispute, not to assume that you're just going to keep your child at school and that's at home, and that's going to be fine. To communicate effectively with the school and the local authority if necessary about what your concerns are and what your intention is. Ask, is this disputed? Is there any concern about this? And if you get the answer, well, yes, we don't agree, don't just ignore that and assume everything's going to be okay, but perhaps get advice at that stage about your particular case. Because it's much easier, well, it's not easy at all, but it's much more effective, I would suggest, to challenge attendance proceedings, you can call them that, or threats in relation to non-attendance, the earlier you get involved as a lawyer. And the further down the line you are, the more likely that the only way to deal with it is going to be to run a defence in the magistrate's court, which is a little risky, should we say. Whereas you might have been able to challenge an unreasonable threat by way of a counter threat of judicial review if you'd engaged early enough. So these are very difficult situations, and I would emphasise again, I expect it to be a very low minority of cases where that kind of dispute arises. But I do think there will be some. I'm certain there will be some, because parents and the system quite often don't have the same understanding of what the child's needs and vulnerabilities are.
Thank you. Steve, I was going to move on now and just spend a little bit of time talking about remedies.
Great.
And I wonder if I can see lots of questions coming in. And so whilst I'm covering remedies, you could be having a look at some of those questions.
Yes, I will. Well. Perhaps Alice and I could try and answer some of the simpler ones in writing while you're talking about remedies, Polly, and then we can pick up some ones to flag orally as well. So
yeah, and I think it would be good. I'm not sure if everybody can see the answers that we're writing. So if you see any really ones that you think everybody would like to hear.
Hang on. Absolutely. We'll hold on to those to deal with them orally.
So we've spent a lot of time talking about what should happen in September and what the rights and responsibilities are on either side. But what happens if it goes wrong and you're in a position where you feel that what should be happening isn't happening? I think, so I set out on this next slide that there are a range of remedies that are available to you. And I put legal action deliberately at the end because it really is a last resort. And there are lots of other ways that cases can be resolved as well. And you have a range of options to choose between. Unfortunately, though, often a number of these remedies aren't very satisfactory in being able to deal with immediate urgent issues which you're facing. So the first, I should say, before you even get to any of these, informal resolution is obviously always the best option. And trying to resolve the matter, whether that's with the local authority, with the CCG, or whether the school, trying to resolve that informally first. But after that, you then need to consider whether you want to be making a formal complaint. And there are a number of bodies that consider formal complaints in the context of education. You have to bear in mind, though, with complaints procedures, is that they necessarily they often take a long time to resolve. And so it would not be unusual if you're going from the beginning stage 1 of a complaints process through local authority complaints and then through to a complaint to the Ombudsman, for example, that you could be looking at a period of 12 months. Now, I think that may well provide a good remedy if you're looking at something that's already happened but is now resolved. But if you're in a situation where the issue is happening now, you might not have that time to be able to wait. And so you may find that you want to try a short complaint first and then need to consider legal proceedings. The other factor that always needs to be considered is the timescales which are imposed on us in bringing legal proceedings. So the main type of legal proceedings we're talking about here, Steve's talked about disability discrimination already, but is judicial review. And judicial review is a legal procedure to challenge the decision-making process and the decisions that are made by public bodies. But they come with them very strict time limits. And they must be brought promptly and in any event within 3 months. And so whereas nobody wants to rush into legal proceedings, unfortunately, the law doesn't often give us much time. And so always bear that in mind. And I've mentioned here a range of bodies also that investigate complaints around education. So the Local Government and Social Care Ombudsman does investigate complaints about the provision of education and special educational needs provision. It did close its doors, sadly, during the height of the pandemic, but it is now considering complaints again. It published a pretty damning report in October of last year, where it said that it actually upheld 86% of complaints that parents bring around special educational needs, which is far higher than any other area that the Ombudsman investigates. And so that is one remedy to consider. Also, the Department of Education are able to consider complaints directly, including where there is a concern that a school isn't complying with its duties under the Equality Act in relation to disability discrimination. So my own view is that the Department of Education ought to be taking some responsibility in terms of monitoring of compliance and accountability of local authorities. And there is a route to parents reporting concerns to the Department of Education. And that is, I think, how, at the moment, the only way in which they can become aware of issues that are arising on the ground. And also similarly in respect of academies, if the education placement is an academy, then the route is to the Education and Skills Funding Agency. So there are lots of bodies that can consider complaints. Ofsted as well has a role. It can't look at individual cases, but it can look at wider issues around a school. And then, as I mentioned, judicial review, always a last resort. And I don't think any parent would ever rush into this, because inevitably any kind of litigation comes with an element of you have to use a lot of energy and time, and so you're not going to embark on it unless you think you're really going to achieve something. But that there are lots of lawyers that will be able to advise on specific circumstances. I've mentioned about time limits. And just briefly in relation to legal aid, this is an area of law which remains in scope for legal aid. Unlike the tribunal, for representation in a judicial review, once you have a proper legal aid certificate, the financial means assessment is based on the child's means. So for many children, legal aid ought to be available to at least cover some of the costs of this and of getting legal advice in these areas. Now, I don't have time to go through the detail of the legal aid rules today, but it's certainly something that should be explored if you're in that situation. So there are a range of remedies. As I said, informal resolution is always the thing to try first. And there's sort of a range of different things as well, dependent on the particular circumstances and often how urgent it is, what it takes, which route you go down. So I'm now going to, I think we've had so many questions, and I want to give us plenty of time to discuss some of those. Steve, is there any in particular that you've picked out that you want to talk about? Oh, and I think you're on mute.
Classic, apologies. One that I'll pick up at, I'm not sure if people can see the questions, but it's at 1:59. If the parents feel the transition back to school is not appropriate for their children, can social services override parents' views? Well, of course, in any area of life, if the local authority considers the child may be at risk of significant harm, then they can and arguably must intervene through initial child protection inquiries under Section 47 of the Children Act of 1989. So the short answer is yes, they can, if they have good reason to believe that the parents are wrong. So that's why the message I'm trying to get across in this session is that parents need to be very careful not to just take unilateral decisions about what's going to happen with their child in September, but to work with the relevant authorities to agree a plan of action. And if that can't be done, if it's clear there isn't going to be agreement, that's the point at which individual advice is going to be particularly important.
I'm going to just pick up a question then, if that's okay. And the question is there a legal obligation for earlier settings to provide provision in education, health and care plan in September? And is the legal obligation the same as schools? Well, I think that the first thing to say is actually the legal obligation is on the local authority, not on the school or the earlier setting. So it's the local authority in relation to education and the CCG in respect of health. First and foremost, it's their legal duty to make sure what's set out in an education, health and care plan is delivered. Now, of course, in practice, they discharge that duty by making sure that they give enough funding and enough support to schools most of the time to comply with those duties. But when it comes to the particular type of setting, the rules are all the same. So if that child has got an EHC plan from September, well, in fact, from now, because the notice will expire on the 31st of July. So from the 31st of July, regardless of setting, if a child or young person has an education, health and care plan, there will be a duty to provide what's set out in that plan. And related to that, another question that I saw earlier on was what happens if a particular local area goes into lockdown? But at the moment, the rules don't make any distinction for that. And so the position would be treated in the same way as the current rules. I think we have had an indication from the Department of Education, though, that they may be considering introducing some local flexibilities. So we will have to wait and see on that side what comes next.
I was just going to pick up a couple of questions as well, and I might share my screen in due course to show some guidance. So the first was, does all of this apply to independent specialist schools? And the answer to that, if you'll bear with me as I try to make this work, can you see my screen?
We can, thank you.
Brilliant. Is that the guidance that we were referring to at the outset that is in the slides is for mainstream settings, and there is separate guidance that you can see on my screen for special schools and other specialist settings, which apply for when schools reopen in the autumn term, although they largely mirror the provisions that we've set out before, but it is obviously worth looking for that specific guidance. Another question that came through, and I'm just looking at my notes of the questions on the side there, you'll be able to see, is whether there's any clear wording to share in terms with mainstream schools who are refusing to secure provision of teaching assistants on the basis they have to be closer than 1 metre and they need to provide social distancing. There is a portion of the guidance that would be of use to you. So if this little bit here that you can see on the screen that begins with measures within the classroom, it recognises that maintaining a distance is going to be important. However, that when people are working with children who have complex needs or who need close contact care, that might not be possible. And it might also not be possible for children to maintain distance. Nevertheless, it's quite clear that the school should be making provision, and it shouldn't be an excuse that distance is required between a TA and an individual. If a TA needs to be in close contact in order to provide provision, then there are sort of questions around PPE, but that's not a good excuse for failing to secure the provision, which is specified under an education, health and care plan. So again, that guidance will assist in that regard. I've got a third, but I don't want to hog the limelight.
No, please go ahead, Alice.
Go ahead, Alice.
Okay, so the third was in relation to the risk of exclusion of some children with SEND as a result of the government's zero tolerance rhetoric about adherence to things like social distancing. There is, in the context of the guidance, again, a section on behavioural expectations. And this does recognise that for some individuals, and you see down here, particularly in relation to children who have SEND, that this may have an impact on their behaviour, and that settings should work with local services to ensure a smooth return. Now, there's nothing specific here about exclusion in relation to children with SEND, although it emphasises what we already know, which is that any exclusion, even for a short period of time, must be consistent with relevant legislation. And I guess the key takeaway here is that the Equality Act hasn't ceased to apply at any point during the pandemic. And in any context where there is a school exclusion or any type of discipline falling short of exclusion, where that is because of the behaviour of a student that arises in the context of their disability, then there will be a potential claim for discrimination arising from disability. So, for example, if a student doesn't adhere to social distancing rules and the school disciplines them for that, and the reason they can't adhere to social distancing arises because of their disability, then there would be a potential claim for discrimination arising from disability against the school, and that could be brought either in the tribunal or potentially if there were other issues that needed addressing in a judicial review. So obviously, I mean, we would be concerned that schools might not bear all of this in mind and might sort of go along with the government rhetoric and try to apply a hard and fast approach, but they still should be making reasonable adjustments for students with disabilities and avoiding discriminatory practices.
Thank you, Alice.
I've got one more, Polly, unless you've got one to...
No, you go.
So 2 o'clock, for those who are able to see, very interesting question, I think. If a parent chooses to educate a child with an EHC plan at home, does suitable education in relation to the elective home education guidance mean they have to provide as best as possible what's in the EHC plan? I'm going to give a classic lawyer's answer to that. It depends. It depends what the EHC plan says, because the legal obligation on the parent is to provide suitable education. There is no legal obligation on the parent to secure the same provision as is in the EHC plan. But if, for example, you've been to tribunal and the tribunal's given a definitive ruling that the child needs a certain type of provision, it may put you on some rather thin ice as a parent to then not arrange that provision if you want the child to be at home, because objectively you've got a decision of a judicial body that says that that is what the child requires. And it may well be then that the local authority says, well, hang on a second, how are you arranging suitable education if you're not making that thing happen? So that's the practical problem, I would suggest. Now, of course, if the EHC plan names a school or institution, that school or institution must admit, and then the local authority will generally want to secure the provision in section F at that school or institution, most of it, or perhaps all of it, because it will be cheaper. And they will say, well, we're not going to fund that at home because it will be double counting and much more expensive. We're making it available at the school. And so that's why it will fall back on the parents generally to need to make that happen themselves if the plan names the school or institution. If the plan recognises that the child is going to be educated otherwise than at school, for example, at home, then the local authority will have to secure all the section F provision at home. So it may, and that could of course be an issue for the tribunal, whether or not it's appropriate for the child to attend school. There's some quite complex issues to unpack in that question. But it is important, I'd suggest, that the EHC plan becomes the benchmark of what suitable provision is for a child who has one. And any significant variation from that is going to potentially lead to the question of, well, how can you say that what you're doing is suitable?
That's really helpful. Thank you, Steve. I know a lot of our questions are often going to be a little bit lawyerly, because so much of this does turn on the individual facts. And so I'm sorry if some of the questions are not able to give you sort of definite answers. But if I could just pick up a few more that I've seen. One of the questions was a concern about schools sending out what's been referred to as reasonable endeavours forms, where they're asking for parents to agree what bits of the plan can be provided. And I think that those, whether or the extent to which they're lawful today is a very different question to the position in September. In September, that there is no longer a reasonable endeavours duty. It is an absolute duty to provide what's in the EHC plan. Now, of course, parents are going to be realistic about that. You know, something is absolutely impossible for whatever reason, and you agree, but they're going to be very, very exceptional cases. The position now, I think, though, is more difficult, because the position as of today and until the 31st of July is one of reasonable endeavours. And what reasonable endeavours means, as Alice said, during the course of a pandemic, is difficult to advise on. So I think certainly from September, which is really the time frame that we're going to be looking at now, then no, reasonable endeavours is no longer a concept when it comes to provision in an EHC plan. There's also been quite a few questions about risk assessments. And again, risk assessments are something which comes out of the downgrading of rights that have happened in the moment. And so the guidance, the first set of guidance on the slides, set out that for each child, the local authority and the parents should work together to carry out a risk assessment, and the school to carry out a risk assessment to decide whether that child should continue to attend school or not. Now, we know, sadly, huge numbers of children, those risk assessments were not completed. But where they were, and they should have been, then in answer to one of the questions, they should always have been shared with the parents, because they should have been prepared with the parents jointly. And then in relation to September, one of the questions is, can a risk assessment be used to say a child can't attend in September? The answer to that is no. The guidance is really clear that unless a medical professional has said that it's not safe for that child to attend school, then it's back to the usual laws which were in place prior to the coronavirus. And so obviously the schools will be doing lots of risk assessments generally, but the risk assessments which are being asked about in the questions only relate to the provision at the moment.
Do you want to go next? You've got one in mind? Because I've got one otherwise. You're on mute, Alice.
Sorry, yeah, there was a linked question actually just following on from what Polly's just said, which was if I decide not to send my child to school because it's unsafe for them, do I have any entitlement to remote provision? Now, the guidance does state that, the general guidance that is on the slide, that where a pupil is unable to attend their setting because they are complying with clinical or public health advice, we expect settings to be able to immediately offer them access to remote education. But I think the really important aspect of that is that that's only going to be where, as Polly was saying, there is clear clinical advice or clear public health advice. And I suppose that might mean perhaps if there's a change in government position in relation to shielding for particular individuals, if you're compliant with that. But it would mean that if a decision's been taken to keep a child or young person at home without that kind of objective support, that the schools probably don't have an obligation to be providing you with remote support on an ongoing basis, because the expectation is that the child will be back in school and that will be how they're accessing their education.
Agreed. I've got a very interesting question. I'm taking one of three that's asked at 2:20. I'm taking the middle one. Do you feel that the strong message from the government about issuing fines for pupils who don't attend school in September will disproportionately impact pupils who are disabled, essentially? That's a really interesting question. Now, the problem is that the statutory regime in relation to, that leads ultimately to fines, we must remember that's the final stage, is in primary legislation. It can't just be ignored. So it's not subject to the reasonable adjustments duties, for example, because those only apply to policies, PCPs. So in a sense, the government's in something of a cleft stick here, because unless it's going to amend the law, and it has done during the pandemic, of course, there were disapplication notices to the statutory regime during the pandemic, but those are going to stop, then it has to say that everyone needs to attend school, or more accurately, everyone needs to have a suitable education, because that's the law. So I'm not sure what else they could do. Will it disproportionately impact on disabled pupils? Yes, of course it will. But that's a problem with the hard-edged obligations in primary legislation. So what we need is, I would suggest, a sensible approach locally in individual cases, and agreed plans of action to get children back to school in a way that's going to be effective and will work for them. But we can't avoid the statutory duties. We can't pretend they don't exist. And it would be wrong for the government to have done so, frankly.
I might just jump in and answer one question. So, because I think it will apply to lots of different scenarios. So the particular scenario that has been asked about is the situation of a child with anxiety and perhaps mental health difficulties, who needs some extra support to get back into school. And so, for example, their parents actually taking them into the classroom, but the school rules that have been put in place because of, from a health and safety perspective, require the child to be dropped off at the school gates. And I can think of lots of examples of where school rules, because of health and safety and because of coronavirus, might be challenging for particular groups. The thing to say there is that these are general policies that schools are allowed to have general policies, but they must make reasonable adjustments for people who are disabled. And so it would be down to the parent and the school speaking about that particular situation. I hope being able to work together to find a solution which accommodates that child. And you never have to go anywhere near as far as you mentioning disability discrimination. But ultimately, that would be the end point, is that if a school is refusing to make a reasonable adjustment, then the final remedy in those circumstances would be a claim for disability discrimination. Of course, it is what's reasonable, but if you're talking about a child or young person who can't get to school at all unless these adjustments are put in place, then I think there would have to be really compelling reasons as to why the school wasn't able to accommodate that.
Absolutely. And similarly on that, a general question about children with tracheostomies being told they just can't go to school. And interestingly, coming in at the same time, another question that schools are just generally citing health and safety reasons for refusing a full-time return. Well, that's just all obviously unlawful, isn't it? Because most children with tracheostomies will have EHC plans, but even if they don't, as I was stressing, the duties on schools to meet medical needs will be there, and the Equality Act duties will be there. And there needs to be some very firm pushback given, I'd suggest, against those kinds of messages, which might involving the Department for Education. It might involve contacting local support groups. It might involve getting the SENDIAS service involved. It might well involve speaking to lawyers. But certainly what it shouldn't involve, I'd suggest, is accepting those blanket responses as being in any way acceptable or lawful, because they're obviously not. So yes, it's no surprise to anyone of the three panelists, I'm sure, but there's a significant variance between law and practice. And the fact that people shouldn't be being told that children with tracheostomies can't go to school in no way suggests they won't be told that. They may well be, but it can't be accepted because it's clearly wrong.
Yeah. And just whilst Alice is choosing her next one, there has also been a couple of comments from people saying, what if between us, parents and the school, we've just agreed that it's okay for our child not to come back? Is that all right? Is there anything else we need to think about there? Well, I think that a head teacher has to decide how, the starting point is, a head teacher has to decide how they're going to authorise absences. And a head teacher retains the discretion to authorise an absence if there is good reason. So if a head teacher is happy with the reason you've given as being a good reason to authorise the absence, that's fine. You know, I think the difficulty comes where the head teacher isn't happy with the reason and marks that as unauthorised. Because when the absence is then marked unauthorised, there becomes a point where then that gets referred to a local authority and you start those sanctions that Steve spoke to you about. But I personally don't foresee, if it's agreed between them and it's the right attendance codes are used, I can't see why that ought to be difficulty in principle. I would say I don't think it's what the government intends though, and I think that the government hopes that children will go back to school in September. But you've got to look at each child individually, of course.
Yeah, great.
I was just looking at a question which sort of flows on from a lot of the discussion we've had about when a decision can be taken not to send a child into school, and that relates to when maybe someone else at home has a complex health condition or a serious condition, and whether that means that a parent or carer can refuse to send a child to school in that situation. Looking again at the general guidance, the position there is essentially that the shielding advice for all adults and children will be put on pause from the 1st of August. And I mean, that may be reviewed and put back in place depending on how the pandemic goes. But the position is, the assumption is that the small number of students who were still on the shielding list and those who have family members who are shielding will no longer be subject to sort of shielding policy and will be expected to go back. But again, this would all be subject to, as we've been covering, discussions with the school about whether or not they agree that that's not appropriate in the circumstances. But there will be a risk that if you can't sort of forge an agreement with either clinical professionals or the school who are happy to deal with the attendances in a proportionate way, that there may be difficulties that could arise if you're saying, well, my child isn't going to go back to school because of the health needs of somebody in our household.
Can I just say that I am shocked, even though I shouldn't be, that some of the individual case issues that are being put on the Q&A, and where I've said to people, we're sorry we can't provide case-specific advice today, we do genuinely mean that we're sorry we can't provide case-specific advice today, because you do all need case-specific advice. I've been giving the search term for my blog, the list of solicitors on there that people can try and contact, very conscious that the capacity of the sector to provide individual advice is limited as well, but people do need to try, because you're all of those people who I've said it to urgently need it. All we're able to do today, I'm afraid, is give a more general steer. And there's a very interesting general question that I was going to pick up at 2:36 on mainstream schools providing catch-up support over the summer or in September. Should alternative provision settings also be providing that? I think the answer to that must be yes. Because if it's a mainstream school that's maintained at least by the local authority, and the local authority is maintaining the AP setting, the alternative provision, then the local authority will be responsible for differential treatment, which will indirectly discriminate against disabled children because they're much more likely to be in alternative provision. If it's all academised and it's individual academies making these decisions, it's rather harder to bring a challenge because each academy or academy chain will have its own policies and have its own responsibilities. But where it's a local area that's still got a lot of maintained schools with local authority control, then there could well be a discrimination challenge there.
Thank you, Steve. I'm just going to share my slides again just to finish up. Can I just ask Alice or Steve whether there are any other final questions or any final comments that you wanted to make?
There's one I'd like to pick up, a very helpful comment at 240 from a lawyer who advises schools and academies, not parents, and flagging that all parties in the system need to gain a better understanding of the relationship between SEN as a concept, special educational needs as defined in Section 21 of the Children and Families Act, and the concept of disability as defined in Section 6 of the Equality Act, and that some children have one or the other, some have both, and the duties, although similar, are different, which is perhaps the best summary I think I've seen. They are different, and the obligation in terms of the duty holder is often different as well, because almost all the SEN duties are on the local authority, save for, of course, the Section 66 duty, notably in the Children and Families Act, which means that schools and colleges have to use their best endeavours to make special educational provision for all children and young people. But the hardcore duties in the Children and Families Act are on local authorities in terms of EHC plan. But the Equality Act duty is very firmly placed on the school. So it is really important to understand for each child or young person, are they a disabled child or young person? Do they have recognised special educational needs? And if so, which legal route are you looking at in terms of understanding entitlements and potential defences as well? So I applaud that general comment, and I'm grateful for it. Thank you. I won't name the person for data protection reasons, but thank you for that.
Okay, I've popped our contact details on the final slide, including our Twitter, and I know both Alice and Steve in particular keep their Twitter regularly updated with the latest guidance and
try.
And so you do follow them, because I think they will always be saying when new guidance is issued or important things are happening that we all need to keep on top of. And the guidance and the position is moving really quickly at the moment. I think even as a lawyer, it's easy to feel overwhelmed sometimes by the amount of changes that are happening. So make sure that you use those links and the up-to-date position in those links, which we provided the resources on the resources pages. Before these slides are sent out more widely, I'll add a couple more in based on the ones that Alice and Steve were sharing with you. And somebody also asked about case law, and Steve works for the Council for Disabled Children in providing some fantastic case law updates in this area. I know Alice helped him with the most recent one. I think it's pinned perhaps at the top of his Twitter feed.
I think so. It was recently. I'll make sure. Perhaps I'll put it back if it's not.
And so that's another great resource as well if you want to be really informed in exactly what the law is saying in relation to special educational needs.
Yes.
Just about takes us to our time. Thank you everybody for all of the questions. I hope that that's been helpful, and I hope that everybody is able to enjoy a bit of the summer before we get to September. Yeah. Thank you so much, Steve and Alice.
Thank you, Polly, for organising all of this and providing this resource for families and practitioners as well. I hope it's been useful, and yes, there'll be more updating to do as we go on, I'm sure.
Thank you.